Good afternoon, everybody.
Good afternoon. How are you? And everybody else.
Good afternoon.
Happy New Year to those of you whom I have not seen this year.
Happy New Year to you as well.
Happy New Year to you too, Ms. Bridgewater.
Position number 6 and we're ready with position number 6 and position 13.
All right, everyone, let's go ahead and get officially started. This is the State Expedited Accusations calendar in the State Court of Fulton County, Georgia. Today is January the 4th of 2023, and I'm Judge Melanie Williams. This calendar is for those individuals who've been recently arrested, but the Solicitor General has already formally accused the cases and bound them over to state court. All defendants, you have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have the right to an attorney at this proceeding today. All participants, this particular proceeding is being broadcast over the internet as a live stream. It's also being recorded. That means any member of the public can log on and watch. All right. I apologize. I did not hear who was at the South Annex.
Good afternoon, Your Honor. We have before you position number 6, Ms. Cole.
Position 6. And Ms. Bridgewater, what's my reset date?
It is January the 17th.
All right. Those who receive a surety or cash bond will be reset to January the 17th. Those who receive a signature bond, whether through the jail or a pretrial, will be reset per the notice. All right. Good afternoon, Ms. Coles. Your case is 23. Okay. Welcome to the new year. CR 00049C. In this case, Ms. Coles, you're charged with criminal trespass with the offense date of January the 3rd. Do you understand your rights today?
Yes, ma'am.
All right. Who is with me from pretrial services? Is there anyone? All right. We'll defer to the state for the history if they have it. Whose case is this for the state?
This would be mine, Your Honor.
All right. Good afternoon, Mr. Hollins. Please proceed.
Yes, ma'am. Your Honor, on January 3rd, this is a criminal trespass case that occurred on January 3rd, 2023, when Officer Lindley responded to a call at the racetrack located at 2429 Bolton Road Northwest in Atlanta, Georgia, when he was met by the manager, Mr. Clements, who explained to the officer that the defendant was sitting outside and refused to leave after being asked multiple times to do so. Officer Lindley attempted to ask the defendant to leave, which she ignored, and eventually stated that she could hear him. And once again, after being asked to leave by the manager, she stated that she didn't do anything and she didn't want to leave. The manager once again asked the defendant once again to try and leave, at which point she became irate and yell and started cursing at them. She continued to refuse to leave and went back into the building, at which point the officer detained her, and this was all caught on the body cam footage from the officer. There is 2 prior cycles. There was a 2022 arrest in which she went through pretrial diversion for reckless conduct. And there's a current open case from May of 2022 for a driving while license suspended or revoked. Your Honor, as a result of the incident, due to the forceful outburst, just from being asked to leave the property, the state is recommending a $1,000 good bond, stay away from the incident location, and the no alcohol, drugs, or weapons while out on bond.
All right. Thank you. Mr. Bartels, is this your client?
Yes, that's my case. Good afternoon, Your Honor. How are you?
Good afternoon. Happy New Year, please.
Yeah, Happy New Year. Good to see you. Yes, I've spoken with Ms. Coase about her case, Your Honor, and this situation, she actually works 2 jobs. I'm advised that Ms. Coase works full-time at Amazon, and that center is fairly close to this this gas station, this racetrack. And she also works part-time at the Marriott in Decatur. And she has gone through a period, Your Honor, where she had some significant financial difficulties. And this case and the pending case with the drug with the suspended license, I would submit that they're really both, because she has been having financial difficulties. If you recall yesterday, the weather was terrible. It was pouring down rain, and she was in the area because she had a gap between her two different jobs, going from the Amazon to the Marriott. And the weather was so terrible, she had to get someplace out of the rain. And she certainly regrets, staying there for that period of time, and wants to apologize for that. But this is really a function of her being homeless. If somebody is homeless, they have to have somewhere to go. She will not be homeless for very long. I'm advised that she's secured an apartment. She's already put a down payment on that. She has a move-in date this coming Friday. And the address I have is 4371 Glenwood Road, apartment M as in Mary 8. That's Decatur, Georgia, 30030. I also have a contact phone number for her. So she's been working 2 jobs and has managed to secure an apartment on her own. She's really been taking steps to improve her situation. The case with the driving with a suspended license was her license was suspended because she could not afford car insurance at the time. So that's what's going on here. She has a 6-year-old daughter. Is currently staying with her mother, but when she gets into her apartment, she'll be taking care of her daughter. Her father also lives in this area, the Metro Atlanta area. I'm advised that her father lives in Noonan. And given all of this and how she found herself in this situation, the steps that she's taking towards improving herself, I do believe it's appropriate to ask for a signature bond in this case.
And Judge, my apologies. We actually are going to recommend a $3,000 signature bond instead of $1,000 good.
That was
Okay,
my.
all right, thank you.
That was exactly the court's inclination. Defendant will receive a $3,000 signature bond through the jail. However, she must stay away from that incident location, have no alcohol, drugs, or weapons.
She's
All right.
advised me that she can go to work without having to come close to it.
All right, good.
Thank you.
All right,
Your Honor.
ma'am, don't go back there, but that's the end of your case, all right? For now. All right.
Keep an eye on your mail. All right, thank you, Judge.
Next, we have position 21, Ms. Stokes.
There was a 21.
No 21.
We have all the way up to 14.
Oh,
I think she's 13, Your Honor.
13. My apologies, Your Honor.
Okay, that's all right.
She scared me right there.
I got very nervous for
Me too.
I muted myself by mistake. Ms. Stokes, your case is 23 CR 00045A. In this case, you're charged with battery family violence with the offense date of the 3rd of January. Do you understand your rights?
Hello. I'm
Okay,
just
please don't speak yet. Thank you. Do you understand your rights, Ms. Stokes?
Yes, ma'am.
All right. Again, no one from pretrial services. Oh, Ms. Roberts, good to see you. Ms. Roberts, can I have this history, please?
Which position was the name, Judge?
Position 13, Stokes.
Give me 1 second, Judge. That's the only history I don't have. I was having GCS.
Okay, we'll defer to the state for this one. Ms. Salette, please proceed.
Yes, Your Honor. And we aren't showing any history for Ms. Stokes. On January 3rd, Officer Ho responded to a dispute call at 960 East Paces Ferry Road, apartment 217. Upon arrival, officers spoke with the defendant and her roommate, Miss Allie Garrett. That's spelled A-L-L-I-E, Garrett, G-A-R-R-E-C-H-T. The officer spoke with the defendant and the victim and surmised that on January 2nd, they had a dispute over dishes, taking out the trash and paying the rent. Ms. Garrett stated that during the verbal dispute, the defendant pulled her shirt and caused a laceration to her upper chest area. The defendant did admit to the officer that she did in fact cause the scratches to the victim's chest. by pulling her shirt. Due to the defendant not having any history, we also made contact with the victim, and she does want the defendant to have a signature bond. We would be recommending a $5,000 signature bond. No contact with the victim in this case, Allie Garrett, and no alcohol, drugs, or weapons while out on bond. The only concern that the victim had was that the defendant's brother or boyfriend someone was present during the incident, and she does have concerns that they may try to reach out to her. So we would like the court to emphasize no third-party contact as well with the victim. But other than that, nothing further from the state.
All right, I'm gonna sound for Allie Garrett. Is Ms. Garrett on the line? All right, Mr. Ford, please proceed.
Thank you. My client is at this point 30, I think she's 22 years of age, 23 years of age. And she's a graduate of Creekside High School. She's also studying real estate. She's gainfully employed for the last 8 months for a company called Haggerty. She's an administrative worker there. She has a stable address here in Atlanta, telephone number, email address. She also has community support. She did give me the telephone number of her father as well. She's a lifetime resident, Your Honor. As been stated, her record is clean. And this was an unfortunate situation, a misunderstanding, as you mentioned, dishes, unpaid rent, and those types of things that happen when you have roommates that live together. After Ms. Stokes was put into custody, the alleged victim did state that she did not want Ms. Stokes to be put into custody. They could resolve it. That's why I'm asking for no further violent contact. That is Ms. Stokes' place of residency. And at this point, Your Honor, we feel based on her record that she has no violent history of anything of that nature. We're asked for a signature bond and no further violent contact.
And Your Honor, it's our understanding that the victim in this case is going to be moving from that location. So we still stand by our recommendation of no contact.
Okay, as the victim is not here, I am inclined to grant no contact at this time. Defendant's gonna receive a $5,000 signature bond through the jail. She's to have no contact with the alleged victim and stay away from that location if the victim is there. She can return one time with a member of law enforcement to ascertain whether or not the victim is there. And if the victim is no longer living at that residence, she can return there. Moreover, she's to have no alcohol, drugs, or weapons. Anything further?
Nothing else, Your Honor.
From the state.
All right, and Ms. Stokes, you're not to have any contact with Ms. Garrett at this time, and that includes social media, text, or using other people to contact her. You understand that?
Yes, ma'am.
All right, best of luck to you.
Thank you.
Okay, who do we have next?
Position 1, Mr. Barnes.
All right, good afternoon, Mr. Barnes. Has courtroom 2 heard their right?
Yes, ma'am.
All right, thank you. Mr. Barnes, your case is 23 CR 00042C. You're charged with fare evasion and 2 counts of obstruction with the offense date of January the 3rd. You understand your rights?
Yes.
All right, thank you. Ms. Roberts?
19 cycles. He appears to be on probation out of Henry County for theft by shoplifting from February of 2019. It was 1 year confinement, 4 years probation. 5 theft by shoplifting convictions, 2 in 2015, 2 in 2012, 1 in 2014. 2 driving while license suspended convictions, 2017, 2012. 4 FTAs, 2012, 15, 16, and 2021. And 4 probation violations, 2014, 15, 17, and 18. And nothing further.
All right, thank you. Ms. Sowery, please proceed.
Yes, Your Honor. This incident took place at MARTA, located at 2420 Piedmont Road in Atlanta. The defendant, he went into the MARTA station without paying the required fee. And when officers attempted to arrest him, he began to pull away and he actually attempted to flee the scene. As we've heard from pretrial, this defendant does have multiple arrests. He has a 2021 FTA where he was actually found guilty. So the state does have concern that he is a flight risk and he does present a risk of reoffending. Our recommendation today is a $2,500 surety bond. That's $500 on the fare evasion and $1,000 on each obstruction to comply with MARTA suspension and no drugs, alcohol, or weapons. Nothing further, Judge.
All right, thank you. Mr. Bartels?
Yes, Your Honor. Thank you. That's my spoken with Mr. Barnes. Does want the court to know, well, he works full time. He works from Atlanta, Georgia. He was born in Atlanta and lived here all of his life. He has family in the area, including his parents and brother and sister. And he wants to ask the court for a signature bond just due to the nature of these charges. We've heard from pretrial, and that is what it is. If the court's not inclined to grant the signature bond, we would ask for a $500 good bond on each charge, and based on the nature of the charges.
All right, and I'm sorry, Ms. Sauer, did the state request to stay away from all MARTA?
I asked for him to comply with the suspensions.
Suspension.
Yes.
Is there a MARTA
Whatever
suspension
order.
in place?
I am not sure. This one's based on the offense date. There may be one implemented within a couple of days.
Okay. All right, at this time, defendant will receive a $2,000 split bond. It will be a $1,000 signature bond through the jail for the fare evasion and $500 on each remaining count. Those will be good for the 1,000 good. He's to comply with all active MARTA suspensions and have no alcohol, drugs, or weapons. Is there anything further?
Nothing from defense. Thank you.
Nothing further from the state, Your Honor.
All right, best of luck to you, Mr. Barnes. Who do we have next?
Position 2, Mr. Bostic.
All right, good afternoon, Mr. Bostic. Your case is 23 CR 00041G. In this case, you're charged with criminal trespass and damage to property with the offense date of July the 25th of 2022. Do you understand, right?
Yes.
All right, Ms. Roberts.
I'm showing 4 cycles with one conviction for simple battery from 2014. On his GCIC, his last arrest is shown as the 1st of this month for possession of marijuana less than an ounce. I'm not sure if that was the same with this case, so that may be okay. And
All right, Ms. Sauer.
Yes, Your Honor. As pre-trial has stated, he did get arrested on the 1st of this month, and that does not appear to be related to this incident. So that's a prior arrest. The current incident is the incident happened at 1225 Fairburn Road in Atlanta. Officers responded to this incident location and spoke with the victim, whose name is Charlotte Childs. She stated that the defendant is her nephew, and he asked her to watch his disabled father while he went out to make money. And when she refused, the defendant retrieved a metal pole and struck the back of her vehicle multiple times, and that caused damage. So we are concerned with his risk of reoffending and that he would intimidate this victim as she is his aunt. The state's recommendation is a $2,000 surety bond, no contact with the victim, a stay away, and no drugs, alcohol, or weapons.
All right, thank you. I'm going to sound for Ms. Childs. Is Ms. Childs?
Yes, she's
present?
on. She's on.
All right, Ms. Childs, if you wish to make a statement, we need you to turn on your camera and unmute your screen.
I don't know how to turn on my camera, but I
We
think
have to be able to identify you, and I have to swear you in.
oh, good. I don't know how to do it on this phone.
There should be a little camera button down in the left corner.
Only thing I see is leave.
Okay, well, we don't want you to do that. There should be a little icon in the bottom left
Only
corner.
thing I see on here is safety driver mode, then leave. Tap to speak, and I have a Galaxy 11 is speaking, so I don't have an up-to-date phone.
Okay, well, we have, in order for you to make a statement, unfortunately, Ms. Childs, we
Let me
have to be
see.
able to see you.
Let me see if I can swing over and see if I see. Okay, here I
There you
am.
are. All right, Ms. Childs, please raise.
Hello, Happy New Year.
Happy New Year. Please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes,
All right, thank you. Ms. Childs, what I'm most concerned with today is whether you wish to have contact with Mr. Bostic.
only in the death of his father, his disabled father, who he tried to abandon on my doorstep and then threatened my life, threatened to attack me, and then attacked my car.
Okay. So you don't want regular contact with him, is what you're telling me? Okay. All right. Is there anything else you'd like to let me know?
I like to let you know that he needs some counseling on his actions. And it stemmed from a long time of a history of when he gets angry, he acts out, and I need him to understand that some of his actions causes repercussions.
All right. Thank you, Ms. Childs, for coming to court and making that statement. I really appreciate it. All right. Mr. Bartels, please proceed.
Yes, Your Honor, thank you. I have spoken with Mr. Bostic. He has ties to the Metro Atlanta area, Judge. He has extended family in this area. He's also employed. I'm told that he works 2 jobs. He works a full-time job at Global Alliance, which is a tire company. And he also does handyman and repair work on the side. And he does dispute certain of the allegations, but he does understand that this is not an evidentiary hearing. It's not a trial. You know, there will be time for that. He does have a 5-year-old son, I'm advised, that lives with him, that he cares for. And this allegedly happened, the date on the warrant, I think, is July 25th of last year. And I know it came up that he had an arrest on January 1st of this year. And then there's this arrest, but this arrest relates to something that happened, it was almost 6 months ago. So, you know, we don't want anybody getting the impression that he was arrested and then just got another arrest subsequent to that. This is from last year. So given all of that, we would ask the court to consider a signature bond. I don't see that there would be any problem with a no further contact order. If the court's not inclined to grant a signature bond, we would ask for $1,000 good bond.
And the state would also ask for a 1-day anger awareness due to the victim's statements made before the court today. Nothing further.
All right. Defendant's going to receive a $5,000 signature bond through pretrial per judge. He's to take the 1-day anger awareness course. He's to have absolutely no contact with the alleged victim in this case, last name Childs, and stay away from the address on Fairburn Road. He's to have no alcohol, drugs, or weapons. Is there anything further?
Further, Judge. Thank you.
Nothing further from the state.
All right. Best of luck to you, sir. Who do we have next?
Position 10, Mr. Leapart.
All right, Mr. Leapart, your case is 23 CR 00054. In this case, you're charged with battery, family violence, criminal
Can
trespass.
I take myself off of camera now, Judge? I'm sorry.
Yes, ma'am. You're free to go. Thank you so much for coming to court. Okay.
Thank you.
Take care. All right, Mr. Leapart, you're charged with battery, family violence, criminal trespass, and cruelty to children with the offense date of August the 18th of 2022. You understand, right?
Yes, ma'am.
All right. Can I have the history, please, Ms. Roberts?
I'm showing 4 cycles. Appears to be on probation for theft by taking from February 10th of 2022, 21 SC 177902, 12 months probation, and nothing further.
Okay, thank you. Ms. Salat, please proceed.
Yes, Your Honor. On August 19th, 2022, around 8 a.m., Officer Morgan was dispatched to 3041 Landrum Drive, apartment H, on a fight call. The victim, Deonshae McDaniel, that's spelled DIONSHAE McDaniel. She stated she told the defendant that their relationship had become too toxic and that she just wanted to co-parent with him. At that time, the defendant became enraged and he began throwing things around the apartment. Officer Morgan observed a broken lamp on the right side of her bed. And Ms. McDaniel also stated that the defendant placed his hands around her neck and choked her while she was holding their newborn son, initials AL Jr. And she stated that this was all due to her request to end the relationship. Officers also observed bruises on the victim's neck from the choking. Our office did try to send this case up to Superior Court. I'm sorry. Actually, we did not send it up to Superior Court because we have spoken with the victim, and now she is giving some conflicting statements at this time. But in December of 2022, the victim did file for a TPO. That case number is 2022 CV 373647. So there is a standing TPO order that was handed down by Judge Manning from Supreme Court, where he's not to have any contact with her. So at this time, the state is going to be requesting a $10,000 surety bond in total, $8,000 for the battery, family violence, and $1,000 on each additional charge. No contact with the victim and a stay away from the incident location. No alcohol, drugs, or weapons while out on bond. The state is really concerned about the facts of this case, with the defendant choking the victim and leaving visible bruises. And due to them having a child together, and what we know about family violence, there is a risk of this occurring again. And also her recently getting that TPO in December, there are additional things going on that we may not know about. Nothing further from the state at this time.
All right, I see Ms. McDaniel on the Zoom conference. Ms. McDaniel, if you wish to make a statement, I need you to turn your camera on. You're not required to make a statement, however. All right, please raise your right hand if you'd like to make a statement. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes.
All right, you can put your hand down. What would you like to tell the court at this time?
On the day of August 18th, we was arguing in the house, and as he was getting his belongings, we were just arguing, but from the bruises, we was both hitting each other. I admit that we was hitting each other. And my neighbors heard the commotion, so they called my leasing office, of course, and my lease office called the police. But him being incarcerated, that's not going to help him or my son. My son need his dad, and I need him myself. So I don't know how this is going to help. My child father, he do have a mood disorder, and he's supposed to be taking pills for that. So that plays a part in some of this. So we have spoken. I recently got the TPO because I was told he came to my home, but it wasn't him. He was just currently in a relationship with another female, but she was doing crazy stuff, and she was making up lies. So that was the reason why I took out the what is it called, the restraining order, temporary restraining order. But he needs to be around his son. Like right now, earlier, me and my son were just stuck outside because I need my child father. We need help. I don't have any family. This is all we got. So him being incarcerated, it's not going to help him because he need therapy. And we have talked about that he need therapy. I don't know if y'all can get him some resources to find a therapist, but he need a therapist. And he have to start taking his pills. But my son need his father. My son is only 6 months.
Okay. Thank you. Mr. Ford?
Thank you, Your Honor. First of all, Your Honor, I'd like to just make an objection to the use of the word that the defendant was enraged. That's nowhere in the report, and that characterization, I think, is somewhat damaging. So at this point, I just want to file a lodge that objection to the use of the solicitor's use of the word enraged. Your Honor, my client is 20 years old. He has his GED. He's somewhat self-employed. He does handyman work, as has been mentioned. He tries to do his best to help support the fact that he has a 6-month-old child. He's been in Georgia pretty much all his life, but a little bit over 13 years. Your Honor, I have a stable address for him. He does have a family in the area, so he does have community support. I think that, Your Honor, a signature bond would be appropriate in this case due to the fact that my client does not have any kind of previous real violent history. So at this point, Your Honor, I think a signature bond would be appropriate at this time.
Is he alleged to still live with the alleged victim?
Your Honor, I looked at the address of the incident location, and it was different than the address that was given to me. So that I cannot answer.
All right. Ms. Salette, anything further, since I did allow the victim to testify extensively?
Your Honor,
No, I'll just, I'm sorry, I thought you said Ms. Salette.
I did say Ms. Salette. Then we'll go back to you,
did you?
Mr. Ford. Ms.
That's
Salette?
okay. But
I just wanted to respond to defense's objection.
Let's not respond to that, please. Let's not.
I just want to say, I emailed him the report where it says that, and so I just wanted to be clear that I didn't just make that up just for my own.
Okay, so let's move past that.
For my own
Anything as
reputation.
it pertains to the, okay, we're gonna move past that. Anything as it pertains to Ms. McDaniel's statement, since it was extensive?
No, Your Honor, I don't, no, Your Honor.
Okay, thank you. Mr. Ford, anything further?
well, Your Honor, I just think that due to the fact they do have somewhat of a newborn, he is helping to financially support. We've had a statement from the alleged victim that she's not really fearful of my client. I think at this point, Your Honor, we're still asking for the signature bond and to have no further violent contact.
Okay, defendant will receive an $8,000 surety bond. It'll be $6,000 on the battery, family violence, and $1,000 on each of the remaining charges. He's to have no contact with the alleged victim. He can arrange transport of the child through a third party, and he is to have no alcohol, drugs, or weapons as a condition. Is there anything further?
No, Your Honor, thank you.
All right. Best of luck to you, Mr. Leaphart. Who do we
Can
have
I
next?
say something?
I've heard from you, Ms. McDaniel. That's going to conclude the case. His case is going to be reset to January the 17th. Thereby bond and the contact with you can be revisited at that time. All right?
Okay. Thank you.
All right. Who do we have next?
Position 7, Mr. Ellis.
All right. Good afternoon, Mr. Ellis. Your case is 23 CR 00053B. You're charged with criminal trespass and obstruction with the offense date of January the 3rd. You understand your rights?
Yes, ma'am.
All right, Ms. Roberts.
He has 4 cycles. The other 3 cycles all appear to be open. The first is out of Fulton County, 22 CP 212260. That's for sale of marijuana, willful obstruction of a law enforcement officer, armed robbery, aggravated assault, interference with government property, possession of a firearm during the commission of a felony, and carrying weapons within school safety zones. The other 2 cases appear to be open out of Henry County from February of 2022. That is for 2 counts of battery, 2 counts of simple battery against a public school system employee, and 1 count of battery on a teacher, and nothing further.
All right, thank you. Mr. Hollins?
Yes, Judge. This is a criminal trespass and willful obstruction of a law enforcement officer charge stemming from an incident that occurred, excuse me, that occurred on January 3rd, 2023 at 175 Piedmont Avenue, which is the dormitories owned by Georgia State University. The officer found the defendant on the property after himself previously giving him a criminal trespass warning. After being given lawful orders to stop, the defendant proceeded to run away from the officer, and he was finally detained and arrested. Your Honor, the incident or the open case from October of 2022 concerns the state for two particular reasons. Not only is the defendant a danger to the community, just because he was found in the same exact area of Georgia State where the October case was, but in that case, he robbed, him and another individual robbed a Georgia State University student in their dorm room in a closet with a handgun with an extended magazine. That entire incident was caught on camera in the exterior portions of the apartment. And it was the exact same location as this particular incident where the defendant was found. The defendant had, there were multiple witnesses and victims in that last case that is, again, still open. And the defendant has had no regard for the safety of others, just in general. And so for those reasons, we do recommend well, he does have a current $1,000 surety bond on each charge. We're asking for a $1,000 cash bond on the criminal trespass, and a $500 surety on the willful obstruction of a law enforcement officer, a stay away from the incident location at 175 Piedmont Avenue, and no alcohol, drugs, or weapons while out on bond.
All right, thank you. Mr. Bartels?
Yes, Your Honor, that's my case. Thank you. I have spoken with Mr. Ellis about this case. He's advised me that, well, first of all, he is employed. He works at the Kentucky Fried Chicken in College Park. I'm also advised that he is going to school. He's studying HVAC repair at Atlanta Metropolitan College. He does have family in the area, so he has ties to the community. I'm advised that he has his sister and his mother, as well as two of his aunts, live in the area. And I am advised that the reason that he went to this location was his girlfriend resides there. And in order to get the job that he has right now, he had to get some paperwork from her as well as his vaccination card. So he would certainly dispute that he is there for any kind of predatory purpose, as the state was trying to suggest. So based on all of that, we would ask for a $500 good bond on each charge for $1,000 total.
All right. At this time, defendant will receive a $2,500 good bond, $2,000 on the criminal trespass, and $500 on the obstruction. He's to stay away from the address on Piedmont Avenue, and he's to have no alcohol, drugs, or weapons while on bond. Is there anything further?
Nothing from defense. Thank you.
Nothing from the state, Your Honor.
All right, thank you. Good luck to you, Mr. Ellis. Who do we have next?
I'm sorry, Judge. What was that bond amount?
2,500 surety, 2001, and 500 on two.
Thank you. Position number 3, Mr. Burgess.
All right, good afternoon, Mr. Burgess. Your case is 23 CR 00043E. You're charged with battery with the offense date of January the 1st of 2023. You understand your rights?
I do.
All right. Ms. Roberts?
I'm showing 3 cycles, 2 out of Georgia, 1 out of New York. He has a 2020 conviction out of Georgia it was for a DUI, but it was amended to a non-fingerprintable offense. And then he has a 2003 conviction out of New York for burglary and robbery. And nothing further.
2003?
Yes, out of New York.
Okay, thank you. Ms. Sowry?
Yes, Your Honor. This incident took place at 7855 Roswell Road in Atlanta. Currently, we only have the warrant, but based on the warrant, it states that the defendant punched the victim, whose name is Valid, that's VALID, last name KHAMISL, punched that person in the face, which caused swelling to the left side. We have heard about the robbery conviction from 2003. That is a violent offense. So this defendant does present a risk of reoffending, as well as that 2020 DUI that was a conviction. The state's recommendation is a $3,000 surety bond, no contact with the victim, a stay away, and no drugs, alcohol, or weapons, and a 1-day anger awareness.
Thank you. I'm going to sound for Mr. Valid or perhaps Miss Valid Camsil? All right, hearing none, or seeing none. Mr. Bartels, please proceed.
Yes, thank you, Your Honor. I believe it's Mr. Cottonisi. I think that's an
Okay, Mr.
Yeah,
Camsil.
I have talked with Mr. Burgess. He gave me some history. He and Mr. Cutnisi actually used to be friends. I mean, they used to have a close relationship. They did have a falling out, I'm advised, sometime last year. And he does deny the allegation. He indicates that he was at a restaurant that's owned by Mr. Cutnisi. He and some friends were there, and they got into a verbal dispute. And he indicates Mr. Cutnisi became very, very aggressive in his personal space, and he had to put his hands up to keep him away. So he does dispute the other allegations. However, you know, I don't see that there would be a problem with a no further contact order. We would not have any objection to that. Mr. Burgess does have ties to the community. I'm advised that his daughter and cousins, as well as other extended family, do live in the metro Atlanta area. He is employed full-time. He works as a security staff at the North River Tavern in Sandy Springs. We are aware of that case from New York. I'm advised that the arrest was actually in 2001, so that was 22 years ago. It's very remote in time. And given all that, we would ask the court to consider a signature bond with a no further contact order. He did advise me that Mr. Cotnisi is actually on his apartment lease because when Mr. Burgess got the apartment where he's staying now, Mr. Cotnisi did that to help him get the apartment. They're not roommates or anything, but just to let the court know that Mr. Burgess is in the process of having Mr. Cotnisi removed from the lease, and he doesn't foresee any problem in doing that. So again, he's asking for a signature bond. If the court's not inclined to do that, we would ask for a $1,500 bond.
All right, defendant will receive a $5,000 signature bond through pretrial per judge. He's to take the one-day anger awareness course. He is to have no further contact with Mr. Kamitsi and stay. Is the incident location the subject apartment?
I believe this was a restaurant or bar. Is that correct, Mr. Burgess?
The incident happened at Mustache Hookah Lounge, which is
Okay.
Mustache Hookah Bar. Yeah.
So stay away from that hookah bar. Have no alcohol, drugs, or weapons.
understood.
And
Thank you, Your Honor.
for the record, the state will be amending this to a battery family violence now that we know that they actually live together.
They never have lived together.
No, it didn't sound to me like they lived together. It sounds like he just helped him co-sign the lease. Is that correct?
That's my understanding.
I mean, the state is free to do that, but it doesn't, that wasn't the information presented today.
Okay, thank you.
Okay, yeah, I think he's just a signature person. All right, best of luck.
Your
to you.
Honor.
Thank you.
Who do we have next?
Position 8, Mr. Glenn.
All right, Mr. Glenn, your case is 23 CR 00050Y. You're charged with simple battery family violence with the offense date of January the 3rd. Do you understand your rights?
Yes, ma'am.
All right, Ms. Roberts.
I'm showing 4 cycles, 2020 conviction for 3 counts of possession and use of drug-related objects. Sorry. And he had an arrest from August of 2020 out of Sumter County for sale of marijuana and possession of a firearm during the commission of a felony, but there is no disposition listed, so that case may still be open.
So nothing violent, just drug related?
Correct.
All right.
I believe, I don't mean to interrupt, I believe this is a cross-defendant case.
It is.
Okay, what is cross defendant with which case?
Number 14.
Okay, so we haven't done that one yet. All right, Mr. Hollings, please proceed.
Yes, Your Honor. And also on that, the case that pretrial was just discussing, that I did speak with Sumter County. It was closed and dismissed in September of 2020. Your Honor, this is a simple battery family violence charge stemming from an incident that occurred on January 3rd, 2023 between Mr. Glenn and a co-defendant, Ms. Van. Sergeant Ireland responded to a domestic violence call at 5710 Stonewall Tell Road in South Fulton. Upon arrival, The victim and co-defendant, Miss Van, was sitting in the driver's seat of her vehicle. After being asked what happened, Miss Van explained that her and Mr. Glenn were driving around doing Uber deliveries with her 5-year-old daughter in the car. Mr. Glenn was the one driving, and as a result of his phone being cut off or disconnected, they were using Miss Van's phone to use the Uber app and for directions and whatnot. While using the phone, Mr. Glenn noticed that Miss Van's ex-boyfriend sent her a text, and this upset him. An argument ensued, and Miss Van got upset at Mr. Glenn and threw food on him, which caused him to grab the collar of her sweatshirt and began shaking her. He shook her hard enough to rip the fabric on her sweatshirt. Ms. Van then proceeded to close her fist and strike Mr. Glenn in the face, leaving a visible red mark above his right eye. The entire altercation was in the presence of Ms. Van's 5-year-old daughter. And the two of them have been in an intimate relationship and living together for roughly 2 months. They do have separate addresses from what I have listed. And as a result of just the physical altercation that resulted from a verbal argument, we do believe that both are likely to reoffend with each other and are a danger to each other. Thus, we are recommending a $3,000 surety bond, a stay away from each other's, and I have addresses for both. No alcohol, drugs, or weapons while out on bond. No contact with with either victim, Miss Marisa Van or the 5-year-old child Soroyal Van, and a 1-day anger awareness class.
All right. Can you give me the stay away address that applies to this case? Is it the
Yes.
Stonewall Hotel?
Yes, Your Honor. Well, hold on. Let me make sure. No, her address I have is 1292 Stoneham Court in College Park, Georgia, 30349. And if Mr. Bartels has a separate or a different address, please feel free to let us know, I guess.
That is my understanding as well. I have his address as the Crystal Lane, or that's a residence where he will be able to stay if there's no further contact.
Correct. We have that as well.
All right. Mr. Bartels, please proceed.
Yes, Your Honor. Well, again, we're not disputing that there are 2 separate residents and there is another place where he can stay. For what it's worth, he tells me that, he is not in fear of his safety from his van. He would not object to no further violent contact. And it is his intention to take the fifth, if that is Ms. Van's intention as well, and not testify against each other. He is employed, as the state indicated. He does work. He drives as Uber, and he also works for Uber Eats delivering food. And he also does other freelance jobs on the side. It does appear that he is charged with simple battery, whereas Ms. Van is charged with battery. Mr. Glenn indicated that he did have marks on his face, so he did have a visible injury, and she has the cruelty to children charge because that goes along with battery. So he does have family. He indicates that his parents live in the metro Atlanta area. We would ask the court, considering the totality of the circumstances, to consider a signature bond. If not, we would ask for a $1,500 bond.
All right. Defendant will receive a $1,500 surety bond. He is to have no contact with the cross-defendant, last name Van, or the minor child whose initials are SV. He is to stay away from her address, I believe in College Park, and have no alcohol, drugs, or weapons. Is there anything further?
Nothing further from defense.
From just ensuring the 1-day anger awareness is not being ordered, Your Honor.
It's not, because it's a surety bond. All right. Best of luck to you, Mr. Glenn. Who do we have next?
Position 4, Mr. Chandler.
All right, good afternoon, Mr. Chandler. Your case is 23 CR 00046Y. You're charged with theft by taking and 2 counts of obstruction. You understand your rights?
Yes, ma'am. I was wondering if I can leave or amend my Benedict Act to 4 and 5, and the right act under God.
Okay, don't say too much. The best thing for you to do is speak to Ms. McLeod, who's here to represent you. All right, Ms. Roberts, can I have the history?
I'm showing 23 cycles, 17 out of Georgia, 1 out of Alabama, 5 out of Florida. He appears to be on probation for bail jumping out of Gwinnett County from December of 2020, 3 years probation. A second probation out of Gwinnett County, also from December of 2020 for possession of meth. A 2015 criminal trespass conviction, another 2015 criminal trespass conviction, 2014 giving false name conviction, 2014 possession of marijuana less than an ounce conviction, 2012 burglary conviction out of Florida, 2 FTAs, 2020 Georgia, 2012 Florida, and then 4 probation violations, 2 in 2015 and 2 in 2014, and nothing further.
Thank you. Ms. Soury.
Yes, Your Honor. This incident took place at a Wendy's located at 1940 Piedmont Road in Atlanta. An officer was flagged down by one of the employees regarding a theft. It stated that the defendant came into the incident location and took the victim's phone that was beside the cash register. That victim's name is Katrina, that's Catrina, last name Witchettt. That employee that actually flagged down the officer, he approached the defendant and saw the victim's phone in the defendant's pocket, and he retrieved the phone from the defendant. Once the defendant was questioned by officers, he got hostile and said he didn't do anything. He attempted to flee and he had to be grabbed by an officer. When he began to pull away, another officer arrived on scene and assisted in placing the defendant in handcuffs. Your Honor, as we've heard from pretrial regarding the history, he does have a risk of reoffending due to those 23 cycles. What's most concerning to the state is the bail jumping conviction that was in 2020 here in our jurisdiction, I believe. The state's recommendation today is a $4,000 surety bond. That's $2,000 on the theft by taking, $1,000 on each obstruction charge, no contact with the victim, a stay away, and no drugs, alcohol, or weapons. Nothing further, Judge.
All right, thank you, Ms. Soury. Ms. McLeod?
Yes, Your Honor. Good afternoon.
Good afternoon.
My client denies any memory of this particular incident, Your Honor. I would also like the court to know that my client is homeless. He has no relatives here in the Metro Atlanta area, he tells me. He doesn't have any home. He doesn't have any forms of assets or anything, Your Honor. So giving him a $4,000 bond, he will not be able to get out of jail. I also believe from speaking with my client that he has some issues at social services. He needs social services help, Your Honor, because he doesn't have a telephone. He doesn't have anything.
Okay. All right. Thank you, Ms. McLeod. At this time, defendant will receive a $1,500 excuse me, surety bond. I'm going to ask that the order just say BHGT to assess any other needs he may have. He's to have no contact with the alleged victim in this case and stay away from the Wendy's on Piedmont Road. Is there anything further?
Is that 500 on each charge?
Yes, ma'am.
Thank you.
And Your Honor, we would ask for no drugs, alcohol, or weapons.
Yes, and no drugs, alcohol, or weapons.
Thank you, Judge.
All right, best of luck to you, Mr. Chandler. That concludes your case at this time.
That's not right. I'm not even finished.
I know it. Position 5, so you have to get
Oh,
up.
no,
and
I
go
have to
to
talk
the
about my
second
Benedict fourth 5 act. No, I have to talk about my Benedict, my 4th act under God. That's not fair. Because
I'm sorry, Your Honor. Position 5, Mr. Shivers.
All right, Mr. Chivers, good afternoon. Your case is 23 CR 00048A. You're charged in this case with fare evasion, obstruction, and simple battery with the offense date of January the 3rd. Do you understand your rights?
Yes.
All right, Ms. Roberts.
8 cycles, and I only saw 1 conviction for reckless driving from 2016.
Okay, thank you. Ms. Soury?
Yes, Your Honor. This incident took place at MARTA, located at 1055 DeKalb Avenue in Atlanta. The defendant was observed entering the MARTA station without paying the required fee. When he was being arrested, he resisted and he actually started to make flirtatious comments towards the officer. He then looked over his shoulder and moved his lips towards her mouth and tried to kiss the officer against her will. The victim, who is the officer, she moved her head, thank God, quickly, and the defendant ended up kissing her on the top of her hat. Those cycles that he has in his history also include a 2021 battery, family violence, and criminal trespass arrest. Though that case is currently open in DeKalb. He also has a 2021 criminal trespass, terroristic threat, and obstruction arrest out of DeKalb that's still currently open. So he does present a risk of reoffending. The state's recommendation is a $3,500 surety bond. That's $2,000 on the simple battery, $1,000 on the obstruction, and $500 on the fare evasion. No further violent contact with the victim, to comply with MARTA suspensions, and no drugs, alcohol, or weapons.
All right, thank you. Mr. Bartels?
Yes, thank you, Your Honor. I have spoken with Mr. Shivers. He does deny certain of the allegations, particularly the allegation.
We lost you for a minute, Mr. Bartels, particularly the
Yes.
allegations.
He does deny the allegation that he attempted to kiss the officer in question or have any contact with her. He does have family in this area. His parents, siblings, and cousins, aunts and uncles all live in the metro Atlanta area. He was born here and has lived here all of his life. So he does have ties to the community. And given all that, we would ask for a $500 bond on each charge for a $1,500 total.
All right, defendant's gonna receive a $3,500 split bond. Excuse me, it'll be a $500 signature bond to the jail for the fare evasion, $1,000 for the willful obstruction, that's a surety bond, and a $2,000 surety for the simple battery. So that should equal that 3,500 split. He is to have no further violent contact with the alleged victim and comply with any suspensions and have no alcohol, drugs, or weapons. Is there anything further?
Nothing further from the state, Your Honor.
Thing from defense, Your Honor.
All right, best of luck to you, Mr. Shiver. What do we have next?
Position 9, Mr. Gordon.
Good afternoon, Mr. Gordon. Your case is 23 CR 00052Y. You're charged with battery and simple battery with the offense date of May of 2020. Do you understand your rights? All right, Ms. Roberts.
We're showing 4 cycles. He had the 2008 conviction for simple battery. In 2019, he took a first offender for arson and reckless conduct, but I'm not sure if that first offender was completed and sealed. Nothing further.
All right, thank you. Ms. Salette?
Yes, Your Honor. On May 28, 2020, the victim in this case, Shantae Ezzard, spelled SHANTA, Ezzard, EZZARD, reported that while she was at her boyfriend's mother's home located at 1829 Campbellton Road, the defendant began drinking and punched her in the face unprovoked while yelling about her coming home late the night before. The defendant then proceeded to choke Miss Ezzard, and Miss Ezzard was only able to get away without any severe injuries because the defendant's friend, who was did pull the defendant off of her long enough.
Hold 1 second, Ms. Salette. Is everything okay at courtroom 2? Okay, continue, Ms. Salette.
Yes, Your Honor. The defendant's friend did pull him off of the victim long enough for her to escape. Ms. Ezzard was transported to Grady Hospital due to complaints of head pain from being choked, and also the officer did notice visible injuries to the victim's face, and the defendant fled the scene before officer's arrival. That 2017 simple battery conviction is with the same victim in this case. And that 2017 arson in the first degree case, that victim in that case is also the victim in this case as well. He was charged for burning her clothes. And he did take that plea in 2019. This incident did occur in May of 2020. The defendant has shown that he has a pattern of abuse against this victim. Although he only has 3 prior arrests, I believe, they are violent in nature against the same victim. And although this incident did happen maybe 2.5 years ago now, we have had contact with the victim, and she is still fearful of the defendant, and she alleges that this was not the first time that something like this has happened, and that can be shown by his history as well. So at this time, the state would be requesting a $10 surety bond in total, $5,000 on each charge, no contact with the victim, no alcohol, drugs, or weapons as well. And as we stated, that is due to history, and his history being solely against this victim, nothing further from the state.
I'm sorry, I didn't hear the amount, Ms. Solet.
$10,000, Your Honor, $5,000 on each charge.
All right, thank you. I'm gonna sound for Ms. Ezzard. Don't see her on here, but sounding for Ms. Ezzard at this time. All right, Mr. Ford, please proceed.
Thank you, Your Honor. Your Honor, my client is 29 years old. He's presently not employed. He only receives SSI. So we're going to be asking for a minimal bond, either a signature bond or something around $500 for each count, Your Honor. He has a stable address. He does have community support due to the fact I do have a telephone number for his mother. He's a lifetime resident. He's not going anywhere. He's not at risk of flight, Your Honor. I have stable telephone number, email address. His record, as mentioned, is I think 3 cycles that where convictions were had. So at this point, Your Honor, we're asking for the signature bond or something around the $500 surety bond on each count due to the fact that he's not employed, he's only on SSI. There should be no issue with any further contact because there's different addresses. I've spoken to my client about the situation, that there's no further contact and to stay away from any address related to the alleged victim, Your Honor. So at this time, we're asking for a minimal bond, signature bond, or $500 surety on each count.
All right, defendant will receive a $1,500 surety bond, 1,000 on count 1, 500 count 2. He's to have no contact with Ms. Ezzard and stay away from the location on Campbellton Road, and as well have no alcohol, drugs, or weapons. Is there anything further from either party?
Nothing further from the state on behalf of ASG Select.
Yeah, nothing further, Your Honor, for the defense.
All right, thank you, Ms. Lowry. I appreciate that. Best of luck to you, Mr. Gordon. Who do we have next?
Position 11, Mr. Price.
All right, good afternoon, Mr. Price. Your case is 23 CR 00044D. In this case, you're charged with simple battery with the offense date of January the 3rd. Do you understand your rights?
Yes.
All right, Ms. Roberts, please proceed.
He has 96 cycles, so I tried to sum it up.
Yeah, we'll just focus on something violent, perhaps in the last 5 years.
Okay, aggravated battery 2017, battery 2019, 2014, 2022. Simple battery 2015. He had 2 parole violations, 2018, 2019. And a sexual battery 2012.
All right, thank you. Ms. Solet?
Honor, on January 3rd, 2023, the defendant did knowingly and intentionally enter the MARTA East Point station at 2848 Main Street while having an active MARTA suspension with an effective date of December 13th. set to expire on January 12th, 2023. The defendant also gained entry into the East Point train station without paying proper fare. In addition to
Yeah,
history.
we object to that, Your Honor. There's
Hold on
nothing
one second.
here.
Ms. Alette, we are doing Mr. Price's case.
Oh my goodness, I'm so sorry. One second.
We're on position 11, Mr. Price. He's charged with simple battery, not fare evasion.
My apologies, Your Honor.
All right.
Here we go. So Mr. Price, January 3rd, 2023, this defendant kicked Tanya Harris. That's T.
Is Ms. Alette frozen?
Yes.
I think the issue is
I believe she's having internet connection issues. I will try to reach out to her so I can present for her.
Okay. Thank you, Ms. Sowry.
I apologize, Your Honor. I'm trying to pull it up now. And may I have the position number?
Position 11, please.
11. And I'm sorry, the name?
Vincent Price.
Okay, this incident took place at 3800 Main Street in College Park. The victim in this case, her name is Tanya, that's Tonia, last name Harris. The defendant kicked her in the back of her left thigh unprovoked while she was exiting the train at the College Park station. This incident was captured and it was viewed by officers at MARTA. As we've heard from pretrial, the defendant has a very lengthy history, specifically those violent convictions that we've heard about, including the sexual battery. We would ask the court to grant a $3,000 surety bond, a stay away, to comply with MARTA suspensions, no contact with the victim, no drugs, alcohol, or weapons, and nothing further from the state.
All right, thank you. Mr. Ford.
Thank you. My client is 58 years old and he denies the allegations that have been put forth here. He has no employment at this time. He does have an address here in the Decatur area. I do have a telephone number for him. He does have community support. I have a telephone number for his sister. He's a lifetime resident of the state of Georgia. So he's not at risk of flight. He has community support, as I mentioned. Any type of bond, Your Honor, would be like having no bond because he has no employment, no income at this time. Your Honor, due to the facts that he totally denies the nature of this particular incident, we're asking for a signature bond at this time due to the fact that it's a simple battery, even though there might be cycles, we didn't hear which ones were actual convictions, Your Honor.
All right.
Your Honor, briefly, I'm sorry, just wanted to note for the record that he does have a March 2022 battery from MARTA, so he's done similar acts like this before, as well as a 2022 battery out of Clayton County that did result in a conviction. Nothing further, Judge.
All right, defendant will receive a $2,500 surety bond. He's to have no contact with Ms. Harris and stay and comply with all active MARTA suspensions, have no alcohol, drugs, or weapons. Is there anything further?
Nothing from the state.
All right, best of luck to you, sir. And I believe the only position we have left is 14.
And
No, we have 12. We have 12. Is that who's coming now? Antoine Sims?
yes, ma'am.
All right, thank you, Mr. Sims. Your case 23 CR 00047Y. In this case, you're charged with criminal trespass and fair evasion with the offense date of January the 3rd. Do you understand your rights?
Yes, ma'am.
All right, Ms. Roberts.
He has 56 cycles. So I went back 10 years. Identity theft fraud when using or possession, identify info concerning a person conviction 2014. Criminal trespass conviction 2018. Forgery, that's 2012. He has 5 FTAs in the last 10 years, 2 in 2018, 2 in 2017, 1 in 2012. And then he had a total of 7 probation violations in the last 10 years, 2015, 2 in 2017, 1 in 2019, 2 in 2021, and 1 in 2022. And nothing further.
All right, thank you. Ms. Salette?
Honor, I apologize. I'm not really sure what's going on with my Wi-Fi. This is the same set of facts that I was stating earlier about the defendant having a MARTA suspension at the East Point train station, and he did knowingly and intentionally enter into that train station while knowing he had that suspension. He also gained entry into the train station without paying proper fare. Your Honor did give the defendant a signature bond in October of 2022 for a criminal trespass against MARTA. You also ordered that he comply with any MARTA suspensions. So due to his extensive history, him currently being out on bond for the same charge, it would be requesting $1,000 surety bond in total, $500 on each charge, stay away from MARTA, and no alcohol, drugs, or weapons while out on bond.
All right, thank you, Mr. Ford.
Thank you, Your Honor. We're going to be asking for a signature bond, Your Honor. The facts and circumstances, we called January 3rd. It was quite a heavy downpour rain. My client mistakenly went into the MARTA station. He should have, he had recognized his suspension, but he was definitely trying to get out of the rain at that time. He has no transportation. He's not employed, but he's a lifetime resident of Georgia. And he definitely has family here. He's 42 years old. He did mention that he has 2 twin daughters at this time that he's very fond of. So, Your Honor, with his stable address and telephone number and the fact that he's a lifetime resident, and due to the circumstances and situation at the time, we are asking for a signature bond.
All right, defendant's going to receive $1,000 split bond, 500 surety on the trespass, and 500 signature through the jail for the fare evasion. He is to comply with all active MARTA suspensions and have no alcohol, drugs, or weapons. Is there anything further? Best of luck to you, sir. Hearing none. All right. Is that completed courtroom 2?
It is, Your Honor.
All right, and we'll be going to courtroom 3. Has Ms. Van heard her rights?
No, she hasn't, Judge. Position 14 here in courtroom 3.
All right, Ms. Van, your case is 23 CR 00051Y. In this case, you're charged with battery, family violence, and cruelty to children in the 3rd degree with the offense date of January the 3rd of 2023. You have a right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney today. This proceeding is being broadcast over the internet as a live stream. It's also being recorded. Do you understand those rights?
Oh, yes, ma'am.
All right. Ms. Roberts, can I have her history?
I am showing 3 cycles, a 2015 disorderly conduct conviction, and then she had an arrest out of Clayton County from May 15th of 2022 for battery and criminal trespass. There's no disposition, so that case appears to be open and nothing further.
All right, thank you. Mr. Hollins.
Yes, Judge. And the state would like to note on that battery and criminal trespass outside of, or out of Clayton County, the victim, or I'm sorry, the defendant is currently out on a $5,000 bond. On that, I did speak with Clayton County Municipal Court and with their solicitor's office, and the paperwork seems to have gotten misplaced somewhere in between. And so they weren't able to tell me who the victim was. However, they still are moving forward with that case. And Your Honor, would you like a recitation of the facts? This is our co-defendant case.
I think I remember the facts. This is the couple that was driving Uber.
Yes, Your Honor.
Okay, I'm familiar.
Okay.
So you go straight to your recommendation.
Yes, Your Honor. The recommendation for the striking of Mr. Glenn in the face with the red mark is $7,000 surety bond on the battery, family violence, $1,000 surety bond on the cruelty to children, the stay away from the address for Mr. Glenn, which is the 5281 Crystal Lane in College Park, Georgia. No alcohol, drugs, or weapons, and no contact with Mr. Glenn.
Okay. Thank you. Ms. McLeod, please proceed.
Yes, Your Honor. My client is 26 years old. She is the mother of two young children, a 5-year-old and a 6-year-old. She does want to have contact with the alleged victim, Your Honor, and she has told me that she has no intention of testifying against him, and he doesn't want to testify against her either, Your Honor. She plans to take the fifth if she's called to testify against him. She tells me that even though they do not have any biological children together, they have separate children and they have been co-parenting them together for some time. She says this is just a misunderstanding between the two of them, and she does want to continue to have contact with him and for him to have contact with her children. Your Honor, my client doesn't have any significant criminal history. Therefore, I would ask the court to give her a signature bond. She is not currently working, so she's not in a position to pay for any kind of bond. If she does not receive a signature bond, she will be stuck in jail and will not be able to take care of her two minor children. I would ask the court to give her a signature bond so she can get out of jail, get back home, and take care of her kids. Nothing further, Your Honor.
And Judge, with the simple fact that we were unable to identify the victim in that previous case, and the open case of the battery, we would recommend a surety bond and no signature.
Your Honor, my client tells me that the person in that other case was a friend of her brother's. It was not somebody she was in a relationship with at all.
All right.
It was not a family violence matter.
All right. Defendant's going to receive a $3,000 surety bond, $2,000 count one, $1,000 count two. She's to have no contact with the cross defendant at this time. I don't believe there's been a sufficient cooling off period, and she must stay away from his address on Crystal Lane, have no alcohol, drugs, or weapons. Is there anything further?
Nothing further, Your Honor. That concludes my business before the court today. May I be excused?
You may be excused, and I believe that concludes the entire calendar. Ms. Bridgewater.
I think that's it, yes.
Will you review for us?
I certainly will, Judge. Once again,
you can be excused.
Okay, once again, the reset date for the SAP calendar is January the 17th. Position number 1 is going to the SAP calendar with a $2,000 split bond. Position number 2 is reset further notice, $5,000 SOB through pretrial per judge. Position 3 is reset further notice with a $5,000 SOB through pretrial per judge. Position 4 is going to the SAP calendar with a total $1,500 good bond. Position 5 is going to the SAP calendar with a $3,500 total split bond. Position 6 is reset further notice with a $3,000 SOB through the jail. Position 7 is going to the SAP calendar with a total $2,500 good bond. Position 8 is going to the SAP calendar with a $1,500 good bond. Position 9, SAP calendar with a total $1,500 good bond. Position 10, SAP calendar with a total $8,000 good bond. Position 11, going to the SAP calendar with a $2,500 good bond. Position 12, SAP calendar with a $1,000 total split bond. 13 is reset further notice with a $5,000 SOB through the jail. And position 14 is going to the SAP calendar with a total $3,000 good bond. Are there any questions, comments, corrections, otherwise?
Thank you. No, that's it.
Okay,
All
awesome.
right. Hearing none, we'll be in recess until tomorrow's SCA calendar. Everyone take care.
Thank
Thank
you.
you, Judge. Have a good day.
All right. Bye-bye.
Thank you, Your Honor.